I'm not quite sure where to start. Israel and Palestine is just a fascinating laboratory for international law, and we could begin maybe in 1917 or before then, or in 1947 or 48. There are a number of starting points. We don't have that much time. I think I'll try to get to the meat of this, but perhaps as an introductory comment, I should point out that the Commission of Inquiry that issued its report this year was not the first, obviously, and you've already cited from the report itself reference to earlier reports. So there have been several commissions of inquiry that have been set up over the years. The most famous of them, I think, is the one that people commonly call the Goldstone Commission, or the Goldstone Report, that was issued in 2009, late 2009, following the conflict in January of 2009. And that report, of course, recommended, spoke about international crimes, placed the debate, and this is something that's really a feature of the last decade or two, that rather than situate these problems and these issues using the language of international human rights law, there's a growing tendency to use the language of international criminal law. And so we use words like crimes against humanity and war crimes, and this has been, as I say, something that's been a feature of human rights monitoring for well over a decade, I guess probably since the 1990s, when commissions of inquiry started investigating conflicts in the Balkans. The commissions of inquiry themselves are a phenomenon in that they have become one of the standard measures that will be adopted, in particular by the Human Rights Council of the United Nations, which has existed for a decade now. So it's called for a number of commissions of inquiry into various parts of the world. Sometimes it's been unsuccessful, actually, in getting the votes necessary to set up a commission of inquiry. But when it's come to Israel and Palestine, there's never really been much difficulty getting enough traction in the Human Rights Council to take that decision. The Human Rights Council is one of the two main councils of the United Nations, but its teeth are a little blunter than the other council, the United Nations Security Council. It too, by the way, has in the past set up commissions of inquiry. It did one for Darfur about a decade ago. That made a report then to the Security Council. So other bodies within the United Nations have done this as well. When the Goldstone Commission made its report and referenced crimes against humanity and war crimes, it also talked about how the case might be brought to the International Criminal Court. And when we use the language of international criminal law, war crimes, it's a very short step then to say, and what about the International Criminal Court? Well, many of you know, of course, that the International Criminal Court, although it today has 123 states that have accepted its jurisdiction, there are some big holes in the jurisdiction of the International Criminal Court. The 7 largest countries in the world in terms of population have not joined the International Criminal Court. And what that does is creates a problem in terms of the exercise of jurisdiction, because the court can only exercise its jurisdiction over the territory of a state that's joined the court, or the nationals of a state that's joined the court. And there are 2 other more exceptional ways that the International Criminal Court can exercise jurisdiction. One of them is when a state that is not a member of the court makes a declaration giving jurisdiction to the court, and there have been a few examples of this, and one of them was by Palestine in January of 2009. And the other is when the situation is referred by the United Nations Security Council, and that's happened twice, once for Darfur in 2005 and once for Libya in 2011. I think the general view is that situations like Palestine would be unlikely to be referred by the United Nations Security Council because of the veto, because there would be powers in the Security Council who would not countenance that. We've had some other examples. The most recent one, not dealing with Palestine, but in that part of the world, was an attempt by France, with the support of the United States and the United Kingdom, to get the court to refer the situation in Syria. and Russia and China both vetoed that proposal. So it's not something that's a very simple thing to implement, and it's not really something that's likely to happen, and wasn't likely to happen in 2009 when the Goldstone Commission issued its report. There was a debate that went on before the International Criminal Court about the status of the declaration that had been made in January of 2009 by Palestine without joining the court, recognizing the jurisdiction of the court. And the prosecutor, the previous prosecutor, there have been two at the International Criminal Court, in April, I think, of 2012, said, I can't accept that declaration because, as far as I'm concerned, Palestine is not yet a state from the standpoint of the measurements that we use in international law. And the prosecutor said, as far as he was concerned, this would require some sort of recognition by the United Nations General Assembly that Palestine was a state. That actually happened later in the year. In November of 2012, the United Nations General Assembly recognized Palestine as a state. We quarrel about whether that meant that the previous declaration by Palestine in January of 2009 was valid, because the General Assembly didn't make Palestine into a state. It recognized that it was a state, so if it was recognized in November of 2012, it was a state. It must also have been a state the day before the resolution was adopted. And so the question is, when did that begin? But the prosecutor and the prosecutor, the new prosecutor, Fatou Bensouda, has taken the view that she's not interested in anything that happened before November of 2012, when Palestinian statehood was recognized by it being granted observer status in the UN General Assembly. So that problem is largely resolved. The Commission of Inquiry, of course, began its work in August of 2014. I was the chairman at the time. I spent about 6 months acting as the chairman of the commission, and resigned for reasons that I've spoken about in public and written about, and you can see it on the Hard Talk interview or somewhere else. I'm not really interested in talking about it tonight if people want to, but it's not the most important thing in this whole issue. I want to talk about Israel and Palestine and the International Criminal Court. The Commission of Inquiry continued its work with the two other members who had been appointed, and issued the report, as has been mentioned, in June of this year. When the Commission began its work, the International Criminal Court was more or less in the same situation as it had been with the Goldstone report. It was an interesting theoretical possibility that the International Criminal Court might be engaged with the court, but it was not something that one could be at all count on. The prosecutor had earlier indicated that if Palestine became an observer state of the General Assembly, then Palestine could then engage the International Criminal Court. But Palestine had not done this. Palestine had been careful not to do it. It had been under great pressure not to do it, including by states like the United Kingdom and France and Germany, all of them ardent defenders of the International Criminal Court, all of them investing significant amounts of energy and money in going around the world convincing states to join the International Criminal Court, with one exception. And they went to Palestine and said, don't do it. There was I think earlier in 2014, when Obama went to the Middle East, he made a specific point of saying to the Palestinians, don't go to the International Criminal Court. And of course, if you're looking for ways to perhaps advance your cause when you have people like the United States and the UK and France and Germany telling you not to do something, my ears would perk up, and I would think maybe there's something interesting that can happen as a result of this. As I say, we labored in the Commission of Inquiry from August of 2014. We actually didn't really begin our substantive work until late in September of 2014. And then we held hearings over several months, some of them in situ to the extent we could get close to the territory that concerned us. We were never allowed into Gaza through Israel, nor were we allowed through Egypt because of the security situation. And so no visit was made in person to Gaza, although we were frequently in contact with people there and interviewed people regularly using Skype and video conference and so on. Also, people managed to get out of Gaza and meet with us in person. So it wasn't as if it was entirely closed to us. It wasn't, but it was limited access, and we weren't able to go on the territory. That maybe would have had more symbolic value than substantive value for the work of the commission, because I always felt that the fact-finding itself went on just fine, and that the difficulty of not being able to go on the ground maybe wasn't entirely satisfactory in terms of the optics of the work of the commission, but that in practice it didn't really change very much. We went to Jordan. We spent a considerable amount of time in Amman, meeting people, interviewing people, and we held hearings in Geneva, and people came and visited and met with us in Geneva, including people from Israel who traveled from Israel, Jewish Israelis who came to visit us and meet with the commission and testify before the commission. And all of that work was done until I departed at a point when we were getting really ready to write the report. I wasn't involved in any of the writing of the report. And I can tell you, I know this is being recorded, and I probably should be a little bit, I'm not going to talk about the internal discussions, except to say that we had not really got to the point of discussing the findings and the substance when I left. I was actually a bit frustrated with that, because my approach to fact-finding is you go out and you learn a little bit, and then you think about it, and then you recalibrate and decide what you have to do next, and where. That's the way I would prefer to operate. But I couldn't convince anybody else on the commission, and they were much more like judges in a court saying, "Let's hear all the evidence, and then we'll talk about what it tells us." So none of that really had gone on before the beginning of February, when I took my leave from the Commission of Inquiry. I expected it to issue the report in March, which was what was required by the resolution of the Human Rights Council, but in fact it was delayed. I don't know that we have a full explanation of the delay. I don't think there was anything sinister or suspicious about the delay. You know, I'm an academic. I teach at the university. I have a lot of research students who promise to deliver things for certain dates, and they often miss their deadlines. So I'm used to people missing their deadlines for entirely innocent reasons, and I suspect that was probably what happened with the Commission of Inquiry as well, that it was simply too hard to get the job done in the time that was required and to write the report. The report itself, and I won't go into all the details about it. I think, again, it's been explained summarily. We could look at the very specific findings. It looked at some of the very specific incidents and types of violation or alleged violation that took place in terms of and I think this was controversial, and I'm sure some people were unhappy about it. And personally, if it had been my own report and I was writing it, I might not have started with the violations of the Palestinians, which is the way the report is written, and I know some people found that a bit difficult to accept. But the Commission did, I think, honor the mandate that it had been given by the Human Rights Council, which was to investigate violations regardless of who was responsible. And it did that in a very proper, I think, manner. It also wrote about it in language that I would call subdued language. It used a very conditional language along the lines of, we have evidence of violations. If certain things were proven, this might then lead to a conclusion that war crimes had been committed. I think it did that. As a general proposition, that was the way the report was written. I think far more conditionally, far more cautious language than you find in earlier reports, like the Goldstone report, for example. The Goldstone report, it was one of the most controversial parts about it, was unable at one point, and when it talked about civilian casualties, where, as you know, civilian casualties are a fact of life in armed conflict. Civilians are not to be targeted, but they are often casualties when military objectives are targeted and when the attack is proportionate. And assessing this is a difficult thing, the targeting, until you know what the person who was doing the firing claims they were targeting. You can try and draw conclusions from what people are targeting, from the trajectory and all of this, but it's not always obvious, and you certainly, it's desirable that you get both sides of the story before you draw firm conclusions about that. Very difficult to do it without that. Of course, Israel didn't cooperate with the Goldstone Commission, and so there were attacks where civilians were killed that didn't have a thorough explanation from the Israeli side, and where, if there, one might presume, therefore, and this is what the Goldstone Commission did, that civilians were in fact intentionally targeted. That was a bold step by the Goldstone Commission, and they were criticized for it. That was the piece that Goldstone later retracted of the Commission report. The Commission of Inquiry, the most recent one, refrained from taking that extra step. So it was very cautious. Now, I think some people may then feel, well, it's a disappointment, that it should have been more, the language should have been stronger and more militant and more demanding. But I think that a lot of that is explained. You may think it's explained also by the changes in the composition of the commission. And that may, I can't tell you what the language would have been if I'd still been there in the meeting, because nobody knows in the meeting, when you're drafting a document, a committee of 3 people, why you choose one word and not another and how that all works out. So I can't second guess that at all. But I do have an explanation as to why the language is more subdued than it was with the Goldstone report. And that's because something very, very dramatic changed in the work of the Commission between its creation at the beginning of August 2014 and the issuance of its report in June of 2015. And that's the Palestinian engagement with the International Criminal Court. I think that made a sea change in how what was expected of the Commission and what was required to do. Commissions of inquiry in the past have generally been created because as a substitute for criminal prosecution. They call for criminal prosecution. They've done it. The Goldstone Commission did so. But everybody knows that that's a highly unlikely occurrence. It's highly unlikely that that's ever going to be the result I'm talking about in the past. And so the Human Rights Council in the past created commissions of inquiry as a substitute for criminal prosecution, knowing that these cases would never be prosecuted criminally. And so you needed a commission of inquiry to investigate and to condemn, to go as far as it could in condemning war crimes, instead of just saying there's enough material for a prosecutor to investigate it. And what happened at the beginning of January 2015, there were, of course, 2 distinct developments. The first is that Palestine made the declaration giving jurisdiction to the court from the 13th of June 2014, which was the start date also for the mandate of the Commission of Inquiry. And then a day later, Palestine joined the International Criminal Court. What that meant by joining the International Criminal Court is that Palestine was giving jurisdiction to the court. Palestine was then becoming a full member, but only from the 1st of April. You can't join the court retroactively. You join it. But you can give jurisdiction retroactively by making a declaration. Other states have done this, and that's what Palestine did. Palestine chose to do it until June of 2014. I think without controversy, it could have done so back to November of 2012. In theory, a state can go back to the 1st of July 2002, which is when the International Criminal Court came into operation. But based on the statements we have from the prosecutor, she would not accept that. She would not recognize the validity of such a declaration from the 1st of July 2002 until November. I think it's the 26th of November, but I can't remember the exact date, in 2012, when the General Assembly adopted the resolution. Neither here nor there in terms of addressing the conflict in Gaza of 2014. There, I think that the jurisdictional problems appear to be largely solved, although, like every issue in law, until you get into the courtroom and you have robust arguments and debate from all sides, all interested parties, the result is always a little bit, we can't be certain. But I think that the smart money legally has reached the conclusion that declaration and that accession by the State of Palestine is valid. And so the International Criminal Court can in fact exercise jurisdiction as of mid-June 2014, and certainly for the future. And that the declaration and the accession cover nationals of the State of Palestine and the territory of the State of Palestine. The territory of the State of Palestine has some gray fringes that we're not entirely confident where they are. This is not as strange or unusual a legal problem as people may think. I don't think it's a majority anymore, but until very recently, a majority of states in the world had border issues, had parts of their borders that had not been defined. Judges have been dealing with cross-border criminal justice issues for decades and decades, and I presume the judges at the International Criminal Court will be able to solve this problem. They'll be able to figure out, for the purposes of the jurisdiction of the court, where the borders of Palestine are. The International Court of Justice did this in 2004 in its advisory opinion, because it came to the conclusion that much of the wall, if not all of it, was built on occupied territory. So if the International Court of Justice can make those kinds of determinations, I'm sure that the International Criminal Court can also figure out that issue. Where that investigation is now is it's been, in a sense, triggered. Trigger isn't a technical word, but it's a word that has a very specific connotation at the International Criminal Court. It refers to a state referring the situation. Have I gone on for too long already? No?
No, please.
Okay.
I was going to suggest roughly 5 to 10 minutes.
Yeah, that's fine. I'm coming to a conclusion. Okay. But the prosecutor has interpreted the fact of making a declaration by Palestine as being something that initiates her own process of what's called a preliminary examination. The prosecutor has to do a preliminary examination before she can go to a chamber of judges called a pretrial chamber, 3 judges, and ask for authorization to go to the next step, which is a full-blown investigation that can then lead to charges and an arrest warrant. And so she's at that preliminary stage called preliminary examination, which is now all quite public. A decade ago, when the International Criminal Court was finding its way, this was a little more opaque, this business of the preliminary examination. And the new prosecutor has gone very public with this. And people who follow the court find this one of the more exciting features of the International Criminal Court, not just for Palestine and Israel, but more generally. As you know, the court has struggled with the fact that all of its cases and situations in the first decade were located in Africa. Soft targets, easy targets, and targets that were not, I think, and I suspect this is the main explanation for why they were chosen, because they're not threatening to powerful states. I think it wasn't a matter of picking on Africa, it was just a matter of going to a place that they weren't going to be stepping on the toes of big, powerful countries. And the new prosecutor seems to take a somewhat different approach. And so if you go on the website of the court, you'll see a list of states that are under preliminary examination, and you have to read between the lines to know what's being talked about, because the one at the top, it says Iraq, but it's not really Iraq that's being investigated, it's the United Kingdom for the conduct of British soldiers in Iraq. And then there's another one that says Afghanistan, and it's not really Afghanistan, it's being investigated too, but it's also the United States for the treatment of detainees in Afghanistan. And then, of course, there's the one for Palestine. The latest development took place 5-6 days ago. The prosecutor issued her annual report on the preliminary examinations. And so there are about 3 or 4 pages, devoted to the preliminary examination with regard to Palestine. And the prosecutor discusses some of the issues, explains the background, confirms what I've just said about her acceptance of the validity of the accession by Palestine and of the declaration by Palestine. So certainly from the standpoint of the prosecutor, there are no doubts. But as I say, this is not a judicial determination. It still could be upset, but I think it's a very confident statement that she makes about that. Then she discusses the various allegations, and here where a lot of it reads very much like what's in the report of the Commission of Inquiry. She talks about the allegations about the violations by Hamas. There's no charge of allegations of violations by the Palestinians in the West Bank, but there are allegations of violations. They're familiar and well known, the main one being the use of rockets and mortars, and the other one, the summary executions that took place for about 20 people in August of 2014. And both of these were also, of course, addressed in the report of the Commission of Inquiry. And then she goes on to look at the violations by Israel both in Gaza and refers to some of the more notorious engagements during the conflict in Rafah in early August of 2014. Does she mention Shujia? I'm not sure, but there's reference there, and it's clear that she's looking at the report of the Commission of Inquiry because there's a footnote referring to it. And in my view, that's exactly as it should be. That's exactly the role now for a Commission of Inquiry. It does its report. It's not acting as a preliminary investigator for a court or anything. It's simply doing its job of investigating the allegations. But it does give the prosecutor then a very credible basis to proceed with her part of the work at the International Criminal Court. So this is how it's supposed to work. This is how ideally it would have worked in 2009, but for the reasons I've explained, it did not. And this time, it seems to me, the system is working more or less as it should. Now, she doesn't come to any conclusions about where she's going with this. The next stage will be and she's done this in other circumstances. She did it recently, we haven't spoken about this, but with the flotilla. Issued a very detailed study explaining why she was not going to proceed with the flotilla, and that with the flotilla complaint. And now that has been overturned by the judges. So the judges of the pretrial chamber have told her to have another look at the material, and the judges of the appeals chamber have confirmed the judgment of the judges of the pretrial chamber. At least they've said they're not going to intervene. And so that matter is more or less back on her plate, looking at the flotilla. The main argument that she used for not proceeding with the flotilla was an issue of gravity. She said there was evidence that there were violations, but it did not reach the level of gravity, mainly because of the number of the casualties. And I think this is obviously the difficulty with the Palestinian part of the investigations, because the number of casualties, direct casualties, fatalities from the rockets and mortars is about 5 or 6. And that would be the lowest number. That's lower than the number of victims on the flotilla. So if that doesn't meet a gravity threshold, I think there's a problem with the rockets and mortars. And then the other issue is the one of the summary executions that were carried out in Gaza in August. And again, this is an interesting one because I think the Commission of Inquiry called it a war crime. I'm not really sure about it. There's an interesting debate going on about whether you can commit war crimes against your own people in a way, and I'm not quite sure how that would fit. There may be a suggestion that it be called a crime against humanity as well. There's finally a piece of it which I think may be the most interesting in terms of the way forward, is that there's a discussion and a reference anyway to the issue of settlements. And there is a provision in the Rome Statute that makes it a crime for a state to directly or indirectly move its own population into the territory of a country that it occupies. This is defined as a war crime in the Rome Statute, and it's just sitting there, obviously, waiting for a full-blown investigation by the prosecutor of the International Criminal Court. So that's where things stand. I think that the Commission of Inquiry did its job in that way. As I say, people may find the language is a little. If you're an activist, you'll find the language a little bit too mild, but the system is working, and the result that it's a better result, I think, than what we could have hoped for in August and September when the work of the Commission of Inquiry began, because there is now a court that's looking at violations, I should say, on all fronts, and they will carry out their work. I say this with considerable confidence in a fair and objective, independent and impartial manner. Sorry for going on so long.
So, good evening, and thank you very much to Bill for setting that out so clearly and succinctly as to where we've reached in the process. Process is a long and arduous process, and of course it's my fervent wish, because we, as lawyers working in this field, want the International Criminal Court to do its job, and to do its job in an efficient and effective way, because that's the way that when the Rome Statute process was set in motion, that's the way that a lot of activists and people that want to see these terrible crimes vindicated, that victims get their day in court, they wanted the system to operate effectively. But the history of the International Criminal Court is it's slow, it's not been terribly effective in all the investigations it's mounted or in all the prosecutions it's undertaken. And so while the Palestinians and people who want the International Criminal Court to succeed, and I'm obviously one of them, will continue to push the ICC to do better, and I think under the current prosecutor there's signs that better things are happening than under the previous prosecutor. I think it's early days, and the Palestinians are not naive, and neither are victims across the world naive enough to just rely on the ICC to just carry on doing its work, given the political pressure that it's under in lots of situations. In Africa, it's under a lot of pressure because a lot of African states and individuals across Africa are very angry that they feel Africa's being picked on. So the ICC is under a lot of pressure, and the Palestinians and those that want Palestinian rights to be vindicated need to themselves apply pressure to get the ICC to do its job effectively. And so part of that pressure, part of that vindication of rights, is to continue the work that has to be done to make sure that national jurisdictions do their job, because there's no tension, in fact, in my view, though it's much more difficult for national courts. They're not resourced to take on the role, but that is part of the architecture of international criminal law. It's the national jurisdictions need to do their work. When there's a suspect in their midst, they have to seek out and prosecute. It's a solemn commitment that states undertook when they entered into the 4 Geneva Conventions in 1949. It's in the common articles in all the 4 Geneva Conventions, but it's in Article 146 of the 4th Convention. And it's a positive duty. Seek out and prosecute those suspected of committing crimes that are then set out in the Convention. So I want to talk about two things. One is the duty of states including Palestine and Israel, to deal with their own suspected war crimes, and the duty of third-party states to prosecute suspects when they have the opportunity to do so. And I want to say something then touching on the Commission of Inquiry's preliminary, their findings, and isolate a few issues that national courts can adequately deal with. But of course, my preference remains, of course, as I said at the outset, for the ICC to do its job. But victims don't need to wait where a suspect enters a jurisdiction. That's really the nub of the point I want to make. So that's the outline, and let me just quickly say a few things then. First of all, Palestine ratified, or acceded, I should say, to the 4 Geneva Conventions in April 2014. So Palestine, like the State of Israel, who are also long-standing parties to the 4 Geneva Conventions, has now a positive obligation to put into laws ways that they can effectively deal with their own war crime suspects. And while I very much agree with what Professor Schabas says, that Palestine's got a less arduous task to do in terms of dealing with its own suspects than the Israeli state has, that's a duty on Palestine. And no one who values human rights should forget that Palestine now has the duty, and it could be one of the beacons of many states by getting on with it and dealing with its own deficit to the extent it can exercise jurisdiction, which is not easy when you're an occupied nation, as Palestine is. Then they have a duty to get on with it, pass laws, and make it possible for their own war crime suspects to be prosecuted under their legal system. And it can't take any lessons from Israel, sadly, on that, because Israel's been woeful in dealing with that. And the latest example in Israeli practice, and this goes to the issues of in the ICC Parliament's complementarity. It also touches on the politics of international criminal law, because, as I said in the outset of this point, it's for states to deal with their own suspected war criminals first and foremost. It's their job to do it. And we should press in Britain for that to be done when there are suspected war crimes, and we have court-martials. We've had a few where that's happened. And in all our jurisdictions where we value that, we want the national system to deal with their own suspects. That's one of the best forms of deterrence, most obviously, if you've got an effective system. Well, has Israel got an effective system? Sadly not, and the way in which that's analysed, first of all, it's important to say that Goldstone, they set up a technical committee that was meeting at regular intervals and sort of faded into obscurity, that was looking at this issue on Palestine's side before Palestine ratified or acceded to the conventions, I should say, and then in this post-Goldstone Commission process, they were supposed to be checking what's happening with domestic systems in Palestine and Israel. Are they doing anything? And they came up with a bit of a blank, and as we know, if we analyse what happened post-Goldstone, there were not many criminal prosecutions of soldiers suspected of committing crimes during Operation Cast Lead. There was one soldier was convicted of a fraud because they stole and used a credit card, and they were the ones that got prison time, and then very few others even faced any form of criminal proceedings at all. That's not an appropriate response to the number of allegations of very extreme use of disproportionate force against civilians and the failure to comply with the principle of distinction, in my view. That's not within the jurisdiction currently of the ICC. So let's move on to what Israel was doing to address all this. So there's a process that many of you may be aware of. After the incident of the Mavi Marmara, Prime Minister Netanyahu set up a prime ministerial commission called the Turkel Commission, so a commission that would report to him. Part of the role of that commission, in the end, in a kind of supplementary report, so they dealt with the Mavi Marmara incident, and that's ongoing in litigation in the ICC and in various national jurisdictions, including, of course, Turkey, South Africa, and Spain. But that was one side of its report. The other side of its report, it made, I think, 18 recommendations about the kind of things Israel needs to do to comply with international standards to do with international criminal law. One of which is what I started with, criminalising the offences under the Geneva Conventions. Israel and a lot of other countries, but most countries have actually dealt with this and criminalised war crimes. Britain has done it under the Geneva Conventions Act, and there are very similar acts in common law jurisdictions. And I think Austria has finally, was one of the last EU countries that hadn't legislated for it. I think they finally legislated it, for certainly all EU countries now have criminalised the offences under the Geneva Conventions. Israel has not done that, and one of the recommendations of Turkle was to do that. Now that was back in February of 2013 that we had those recommendations. Now what Netanyahu did is he set up a supplementary commission to look into implementation of the recommendations, but he didn't do that for a year after the report. So a year went by, nothing happened with any of those recommendations, zero. Then a year passes and Netanyahu says, well, I'm going to appoint you, Mr. Kahanover, under a new commission to look into the Turkle 18 recommendations. And what's happened with that? Well, the summer's events came and went, and at the end of the summer of 25th of this summer, so those events of 2014 came and went, the ones that are now the subject of the Commission of Inquiry report and are being looked at by the ICC in its early stages. So that all went by, no report. Then in September of this year, we finally got the report of the Kahanover Commission. What do? They propose that Israel criminalise torture and crimes against humanity, and in a very specific way, which is not compliant with international criminal law, by the way. But war crimes, no, that's kicked into the long grass. And there's a reference to military law dealing with certain war crimes, but it doesn't deal with the majority of war crimes under the Geneva Conventions. It's absolutely clear. So Israel has a democratic deficit. It has a Geneva Conventions deficit, which is massive. So how it claims it will deal with issues of complementarity when it hasn't put itself in the position to prosecute on most of the allegations that we're talking about, it now defeats me. Because it's not, anyway, if it did it, it would be unlikely to be retrospective. So it doesn't deal with the situation as it was in 2014 anyway. But they're not putting themselves in a future position as things stand, in my view. There are a number of other critiques, and Yeshdin published in October a very full critique of what the Kahanover Commission came up with. And so the summary point to make is that Israel is not in a position either to deal with the offences back in 2014 under its criminal law properly, in my view, and it's not currently planning to place itself in a position in future to do so. And when the prosecutor looks at issues of complementarity, she will struggle to find a way in which these crimes can be prosecuted in Israel. Are they being even investigated in Israel? Well, post the events of 2014, the summer of 2014, Netanyahu and the military attorney general put in chain a number of investigations. The only investigation that could even potentially look at the criminal liability of civilian leaders and military leaders, and only potentially, was the state comptroller, who's a kind of national ombudsman. That is not a criminal investigation of any kind. So let's not be deluded. The state comptroller could not bring charges or make an effective criminal investigation into the leaders. So that's a kind of, in my view, as a lawyer looking at it, if this was happening in the UK and we gave the parliamentary ombudsman to look into the alleged crimes of Jack Straw and Tony Blair in relation to the events of the Iraq War, we'd sort of say, well, there's something wrong here. That's not really the role of the parliamentary ombudsman. That's the role of the DPP and the police. So that hasn't happened in Israel. So we cannot miss the fact that the military advocate general and the various investigations, and there are several types, this time around slightly learning from Turkle but not fully applying the 18 recommendations, there has been a slight attempt to move away from the chain of command in some of the investigations. But the proof of the pudding is still in the eating. How many of these investigations has resulted in a single prosecution of a single Israeli officer of any rank? Well, I don't see any arising out of the targeting of civilian buildings, which is well covered in the Commission of Inquiry's report. It deals with 12 family buildings in the Commission of Inquiry report. Professor Schabas maybe wants to say more about that and principle of distinction, etc. But it's very difficult to see how these inquiries, which have now gone on for over a year, because a lot of these inquiries were announced and set up very soon after the events. So they have been going for more than a year, some of these investigations. And I can tell you that colleagues I deal with in Gaza, the Palestinian Center for Human Rights, they understand there is no option but to cooperate with these investigations, however bad the history of previous investigations is. There's not an absence of cooperation by the victims. They're trying to cooperate. They've been meeting the investigators at Erez border. There's, in fact, at least the victims, in some cases, are actually being interviewed. In Operation Cast-led investigations, there wasn't even a pretense of trying to find out from the victims what their accounts were. There was no such even pretense. This time, whether it's a pretense or has substance is something we've yet to see. But you can't call the system rapid or effective as a victim if you're still waiting over a year after these very serious events. So what will we find out from any of that? Well, the most important thing is if there are no charges and therefore the matter's put to bed in Israel, will the Israeli state provide all this material that's collected, its apparent check on the chain of command, all of its discussions, will it actually provide the underlying evidential material, not its conclusions from its material, but the evidence it's collected in its own investigations? Will it willingly hand that over to the ICC as a kind of audit on Israel's? And that is a big test of the Israeli state's cooperation. There's a note in the document that Professor Schabas just mentioned, the report issued just a few days ago, which is kind of like an annual report. And it says that the Israeli state has indicated its cooperation, I think in May. I'll read you what she says. In July. On 9th of July, the government of Israel announced that it had decided to open a dialogue with the office over the preliminary examination. In May 2015, the government of Israel published a report on factual and legal aspects of the 2014 Gaza conflict. That is correct, it did. It didn't result in any... That report included a report on certain investigations which it said it had closed and found there was no case to answer of any soldiers in any part of the chain of command. So it has published at some point the negative outcomes, but it's certainly not published an outcome which has led to anybody being charged. So the question I have for the Israeli state is, if it's proud of what it's doing, it should be clear that it's able to hand over this and assist the prosecutor in looking into whether or not these allegations have been properly investigated. I still say, how are these cases ever going to be prosecuted properly? The whole range of cases, especially against commanders and civilian leaders, which haven't even been the subject of any form of investigation by the Israeli state. So I would say some of the most important allegations, which are command decisions about what to do in terms of how to define targets as civilian or military targets, those kind of issues that go right up the chain of command, and particularly big decisions that were made, for example, in the beginning of Operation Cast-led, there was a shock and awe decision about bombing certain police stations in the very first day of Operation Cast-led. Similar big operational decisions are not being looked at all by the Israeli investigation. So the question remains how they will be looked at by Israel and then by the ICC, and how much there's going to be genuine cooperation. That's something that the world should demand of Israel, as it should demand of every state that's being investigated by the ICC, or every territory where there's an issue that the ICC investigating. And Israel doesn't need to feel picked on in that respect. It should talk to a few African countries about how they feel picked on. So that really is the wrap-up on that issue. So coming back, because I want to give time for there to be discussion. Yeah, so let's go back to the what I started with to some extent, which is, well, that's the ICC process. That's what's going on to the extent that we know what's going on in Israel and Palestine. Not much on Palestine. Very dubious, in my view, investigations on the Israeli side, but let's see. Many of them haven't finished. In the light of that, what do victims do? Do they just sit back and say, well, we'll wait for these processes and we'll keep pushing the ICC? Well, in my view, there is another set of alternatives, and they're very difficult. It's not easy, but the continued collection by organisations like the Palestinian Center for Human Rights in Gaza, by Al-Haq in the West Bank, of collecting evidence of events that are unfolding right in front of our eyes, events in the West Bank, events, the settlement expansion, which is constitutes in part of its activities a war crime, evidence collected in relation to the individuals making decisions. There are individual identifiable commanders and civilian leaders who are making decisions. Evidence related to their conduct, both in Gaza and in the West Bank, has to continue to be collected, partly for the day that we hope the ICC will take jurisdiction, but partly in order to enable national courts who have the criminal law in place to exercise jurisdiction. We in the UK can do so as long as the person doesn't have a form of immunity. Either they're a serving Prime Minister or Head of State or a Foreign Minister, they will have immunity in the national system, not in the ICC, but in the national courts of any country. So we can't deal with the people who are in those current roles. We can deal with former members of people who fill those roles, and there's evidence that's been collected against them and that enables courts, in my view, to have jurisdiction. A few words about how effective that is. Of course, we've had very few national courts exercising international criminal law jurisdiction, and an increasing amount over the last 10 years compared to if we had this discussion 10 years ago. The number of national court convictions and prosecutions was relatively low, but it accelerated partly due to Rwandan cases coming more into national courts and more genocide cases in national courts as opposed to going to the International Tribunal. But not just that, other cases now there is a track record of national courts being able to deliver justice in international criminal law cases. We have a case in the UK to do with a colonel from Nepal, which my firm was involved in assisting the victim in bringing about prosecution. And we have the earlier case of Zardad, the Afghan warlord. So it's been shown that although it's expensive and although it's difficult, a victim's rights can be vindicated in a national court, but it's no more difficult and costly than the very costly apparatus that exists at the ICC. Of course, everyone's preference remains for the ICC to exercise jurisdiction, but national courts can do it. They've shown an ability to do it in the Netherlands, in Germany, in Britain, to a certain extent in France on torture cases. There is certainly the ability to deliver a fair trial to a suspect. And so individual victims from Gaza and West Bank can rest assured that lawyers like me and in other jurisdictions will continue to look for opportunities to bring suspects before the criminal courts in national jurisdictions where the laws permit it. And I can answer more questions about which countries and how that's possible, difficult as it is, if we get into it in Q&A. And that's all for now.